Hi there, I'm immigration attorney Heather Poole. With California, Colorado, and other states now legalizing pot, are you wondering if you're safe to light up? Will a joint get you into trouble with immigration? Let's see. Every immigrant who applies for a green card through the adjustment of status process in the United States goes through a medical exam conducted by a USCIS-approved doctor. Part of this medical exam is a blood test. The blood test is going to test for any controlled substances. If you have smoked pot in the past few weeks or even longer, it's likely to show up on your exam results. Even if it is legal in your state to smoke pot, this result on your medical exam could potentially bar you from getting a green card. Marijuana possession or use is a federal immigration law violation. It's a crime. Marijuana appears on the federal schedule of trafficked illegal substances, and under the Federal Immigration and Nationality Act, an immigrant can be denied a green card if USCIS believes that the immigrant is a drug abuser, which they can conclude if there are traces of an illegal substance in your system found on this medical exam. Even if active drug influence doesn't show up on your blood test, can you purchase and use pot? Could that undermine your case in other ways? You betcha. First of all, what if you're using bank records or shared credit card statements with your spouse and you're using this with USCIS to prove a bona fide marriage and financial commingling, but there are obvious purchases on the statements from marijuana dispensaries? Remember, even an admission of drug use or to the essential elements of a crime of possession of marijuana can be considered the same as being convicted of a possession under federal immigration law of a controlled substance for purposes of eligibility for a green card. And lying at the green card interview when the officer asks you about your drug use when the records show that you have been making purchases can create even more trouble for you. What if you are convicted of a DUI for being under the influence of a controlled substance or prescription drug? What if that drug is marijuana, even if legal in the state? If it led to a conviction that brings the drug to the attention of USCIS, then you may run into an admission of drug use problem. What if you travel to Mexico for the weekend? CBP pulls you out of line and finds joints in your bag. You can be thrown into removal proceedings if they believe you are an addict based on the quantity they find. If the drug in question, for one simple possession conviction for marijuana under 30 grams, or that you admit to using is 30 grams or less of marijuana, you would have the potential option to apply for a waiver of inadmissibility, so you could still obtain your green card. This 212H waiver requires that the possession happened more than 15 years ago, or that you have since been rehabilitated, or you have a U.S. citizen or lawful permanent resident, spouse, parent, or child who would suffer extreme hardship if your waiver is not approved if you had less than 15 years used the drug. This waiver would also require that you otherwise possess good moral character that would be deserving of a positive exercise of discretion. The officer deciding your waiver must like you. Federal law takes drug use and use of controlled substances in any manner really seriously. Even if you can legally purchase baggies of pot in California, if you are pulled over by a Customs and Border Protection agent or referred to CBP by the local police who pull you over, and they find bags in your car or in your glove compartment, you could also be charged with inadmissibility ground of being suspected as a drug trafficker. This is not just meant for cocaine lords. This can happen for large quantities of marijuana. This is a scarier inadmissibility ground than a drug abusing ground, as a drug abuser can be something that can be overcome within a year when you retest, when you have a new blood test, if you have a new medical exam, if you're trying to show that you're admissible to becoming a permanent resident. However, drug trafficking is a different standard. You don't have to be convicted of any drug crime, nor do you have any admission, nor do you have to ever be arrested for any drug crime or charged with any drug crime to still be considered a drug trafficker under U.S. federal immigration law. The inadmissibility standard used against you is one that states, does the consular officer or the Attorney General acting through DHS have a reason to believe that you are a drug trafficker? The fact that they have found multiple baggies in your trunk or in your glove compartment, even if you can prove that they were legally obtained, does not stop CBP or ICE from making that conclusion. I have seen people get into trouble like this when they buy drugs in California, for instance, where marijuana is legal, or Colorado, where recreational marijuana is legal, and then travel into another state to visit someone else. In that other state, possession of marijuana is not legal. They get pulled over by the police and charged, or they get pulled over by the police and referred directly to ICE, who places an immigration hold at the jail, and they fall into immigration's hands. And given the amount of drugs that may be considered to be beyond mere personal use of drug possession, based on the intent to sell, based on the amount of drugs or drug trafficking, they could be in real hot water. There's no standard for how to figure out what is the minimum amount, nor what they mean by what is a reason to believe that you're a drug trafficker. How does one overcome reason to believe then that she is a drug trafficker? The burden falls on the immigrant to prove that she's not a drug trafficker. Did you know you were transporting that much marijuana? The standard for proving reason to believe is easier for the government to prove against you. The Department of State's Foreign Affairs Manual notes that because the reason to believe threshold is substantially lower than that's required for a conviction, the government may be successful in proving a reason to believe finding of inadmissibility blocking your green card, even though criminal charges against you were dropped or never really formed the basis of a conviction. So even if you were a permanent resident, if you've not been safe for you to smoke pot or purchase marijuana legally in the state where you are located or reside, you can still be deported for any controlled substance violation under federal law. USCIS can always refer you to the Attorney General for prosecution under federal immigration laws. Under federal immigration law, any lawful permanent resident who at any time after admission has been convicted of a violation or conspiracy or attempt to violate any law or regulation of a state, the United States, or a foreign country related to a controlled substance other than a single offense involving one's personal use of 30 grams or less of marijuana is deportable. ICE can look at your bank records, your driving record, and any parts of your life paper trail to conclude how much drug use you've been able to charge you as a deportable addict. Be careful. If you wish to partake in regular marijuana use, it may be better to become a citizen first to eliminate the danger of potential deportation.